Today, we're discussing how to fast track workplace investigations. It can be extremely frustrating when you have an employee who comes forward with serious concerns and you take those concerns seriously. You try to meet with them to understand what they have experienced, and you want to start your investigation to figure out what happened so that you can solve the problem. But before too long, you are met with obstacles. Maybe the individual starts changing their complaint and adding to it. They aren't being that responsive when it comes time to setting up a meeting with you. And on the list goes. Before you know it, you are sitting there and getting pressure from management saying, hey, what's going on with this investigation? This person raised serious concerns of discrimination or harassment. And we want to know, do we need to discipline someone? Do we need to let someone go? Is there something problematic happening in the workplace that we need to address? And you can't solve that problem because you can't get the answers that you need. And that has a real impact in terms of that problem itself. If you can't solve that in a timely way, and to the extent that there are problematic things happening, the situation is getting worse while this investigation drags on. So today we are going to look at some strategies for how to deal with that. And I understand the frustration that you have experienced with this issue because I've experienced those same frustrations. And we had an investigation not that long ago where the complainant came forward and she complained of serious issues of racial discrimination and systemic discrimination, and indicating she hadn't felt safe in months. And despite bringing these issues forward, no one had taken any steps to ensure her safety. And as we reached out to her to look into this issue, we were surprised that she was unresponsive to our emails. And so we tried phoning this individual, and she was unresponsive to our phone calls. When she finally did get back in touch with us, she had questions about who we were and whether or not, in fact, we were neutral third parties who were there to properly investigate her complaint. It was her view that this was all a sham, that we weren't, in fact, neutral, and that this had more to do with covering up the allegations that she had made as opposed to resolving them. So right from the get-go, you can get a sense of the individual that we were dealing with, and her representatives were of the same mind. We had to engage in discussions about and explain to them our role and who we were and our reputation, and gain their trust that we were here to do an honest job. When it then came time to scheduling the interviews, we then found out, well, this individual didn't want to sign a confidentiality caution. In essence, she wouldn't agree to keep in confidence the information that we were going to be discussing during our investigation interview. So again, that presents another challenge, especially in this day and age when many of these interviews are being conducted via video conference. You can't have someone who is going to be recording this interview and then broadcasting or publishing it on a whim at some future date. So that added another layer of complexity to the case. That necessitated having in-person interviews, and now we have to schedule a convenient time and a location to meet. And you've got the schedules of the investigator and the witness and their representatives that need to be balanced out. And so it doesn't take much for these what should be a straightforward step, and in terms of just initiating or starting the investigation, it doesn't take too long before things can happen, or these obstacles are presented, and you end up incurring a significant delay. So a process that should have taken a couple months to resolve in terms of that investigation, a 2 to 3 month investigation now becomes a 4 to 6 month investigation because of significant delays that you may experience on the front end. So we're going to go through the various stages of the investigation and look at the risks at each of these stages, and then examine some of the strategies that we could put in place to address those risks. As you know, once you've scheduled that meeting, the initial interview with the complainant is about letting them tell their story, right? We are there to hear what they've experienced, to collect the necessary details, the who, what, where, when, why, and how. We want to get enough detail so it feels like we were in the room and we understand exactly what that individual has gone through. And we want to find out, were there any witnesses to these events? We want to get all of that information so that at the end of the day, we can prepare a list of those allegations with sufficient detail to give that to the responding party to say, hey, here are all of the things, all of the allegations that have been made against you. The respondent then has an opportunity to review that list and come to a meeting prepared to give a response. If there's a delay in terms of those particulars being prepared and drafted, that's going to result in a delay meeting with the responding party, right? No one's going to want to schedule a meeting if they're not aware of what the allegations are that have been made, or whether or not they're going to have enough time to review those allegations and come prepared to that meeting. So getting the particulars drafted is a very important stage of the process. And there's two parts to that equation, right? You've got to conduct the interview and collect the information. And then it's on the shoulders of the investigator to make sure that they review that evidence and that they draft the particulars in a certain amount of time. So within our firm, again, depending on the nature of the complaint and how long that interview was and those factors, we typically have a performance metric of within a couple of days of completing the interview, we have particulars of the complaint drafted and into the hands of the complainant for them to review and to get back to us to say, yes, I reviewed the list that you prepared. It is complete. It is accurate. Please go ahead and conduct the investigation within that framework. So again, you, the investigator, you have to get that work done and then put that into the hands of the complainant and make sure that you are getting a timely response from them. And we've experienced delays at this stage too, where we do our part, like I said, to get the particulars drafted, but you turn that over to the complainant and they take their time getting back to you. And so you're then having to follow up with them to say, hey, did you review the complaint? Does it capture your story? Have I accurately outlined all of the things that you are complaining about? And this is important because this is essentially going to form, my mandate as we go forward with this investigation. So again, any delays at this stage is going to push back the subsequent interviews that you need to complete in this investigation. So what can we do, right? Like that, here's the issue. And we've got, delays at the interview stage. We've got potential delays when it comes to approving the particulars, and all of that is pushing back your investigation. And you're sitting here, thinking, well, I've done everything that I can do. Like I can't drag this person into the fight. I can't make them do these things, and I feel stuck. Like, how do I solve this problem? So, here are some of the things that we've adopted over the course of our practice that we found effective. Number one is setting deadlines. Early on in the process, once you realize the type of complainant or witness that you are dealing with, and you start being presented with these obstacles, it gives you an opportunity to be assertive with that individual and to say, look, we are taking your complaint seriously. We want to know if you have been subject to discrimination or harassment or sexual harassment, but we need your cooperation. And that means you need to sit down with us and make yourself available for an interview so that we can hear your story. And if the person doesn't comply with that, then it's a matter of following up to say, look, we understand that you've experienced this issue, and we are going to move ahead because we've got a statutory and a common law obligation to do so. We're going to move ahead and investigate that complaint. We may not have it perfectly right because you haven't cooperated in terms of meeting with us. So unless you get back to us, and again, give them a deadline of within a couple of days, because this is now the second or third communication that you've had with them. If you don't get back to us within the next 48 hours, we're going to move ahead and with the investigation and based on the allegations as we're aware. And that would simply be based on the verbal or the written communications that the complainant may have had with you to that point. And then you move ahead with the available information. I also find it helpful at that stage, just before I move ahead, to point out to the complainant or whomever the uncooperative party is, to let them know that, hey, look, there are consequences here for you not participating, right? And to the extent that this issue comes down to credibility, that we are only going to have one party's evidence to rely on here. And therefore, as we move forward, if we only have their evidence, we're making conclusions based on that evidence. And this may not be resolved in your favor because we simply don't have the information from you. Or there may be other allegations and other incidents that are known to you but are not known to us. So we can only move forward with what we're aware of. And those things that are only known to you will simply not be investigated, or certainly won't be vetted in a thorough way. And I like to let the other side know that these are the real consequences with respect to the investigation. And that's quite apart from any consequences related to their employment. I found that, and this is just anecdotal, I found that this is a really big problem for public sector clients, where employees don't really appreciate that they can be disciplined, and that they potentially face a termination if they don't cooperate with the employer's investigation. And again, with many public sector investigations, I have noticed that you do get parties and witnesses dragging their feet because somehow they feel sheltered from any consequences to doing so. So at least from the investigator's perspective, if you highlight, here are the consequences for the investigation itself, that gives you some leverage and might spur some cooperation from the other side. And that's quite apart from any other consequences that there might be, again, by way of discipline or dismissal. And then the other part to setting deadlines is going to be documenting those steps. So throughout the process, you want to make sure that you are documenting all the times that you reached out to this individual. So all of the phone calls, and you want to also record whether or not you left a voice message for the individual, and or if you spoke with them, what were the details of that conversation. You want to map out the emails and the dates that those emails were sent, and whether or not you got a response to those emails. So again, depending on the frequency of these communications, in some of my investigation reports, we've put together a chart that will outline, here are all of the occasions that we reached out to this individual and invited them to participate, and for whatever reason, they chose not to, or they eventually participated at some later date. And so here was the delay that resulted, based on that lack of cooperation. You want to make sure that you document those steps, because you'll be surprised that these same people who are dragging their feet, who aren't responding to your emails, and who are not approving the particulars of the complaint, and who are simply frustrating your investigation, these are the same people who at the end of the investigation are going to raise concerns about, guess what? The delay. The people who caused the delay are going to, at the end of the process, say, hey, we can't trust the results of or the conclusions that were reached here because of the delay. And that somehow undermines all of the evidence that was collected and the conclusions that were made. So to address that, you want to be proactive in terms of documenting all the steps that you took to encourage their participation. And at the end of the day, you're going to do the best that you can do with what you have. So again, you want to make sure that you have documented the process. You want to make sure that at the end of the day, you're able to show that we had a fair process, right? And that involves allowing the complainant and the responding party to participate in the investigation, and the fact that you've documented the opportunities that you allowed them just bolsters or strengthens your conclusions and that process at the end of the day. So again, you don't need to be perfect. It doesn't have to be a perfect process, but what you want to avoid is any party making a credible argument that, hey, look, you didn't give me a fair opportunity to participate. I didn't have a right. I had a right to be heard. I wasn't given an opportunity to be heard. So that's important in terms of making sure that you engage, you conduct an investigation that is going to stand up to scrutiny at the end of the day. And so, again, you want to be mindful here of the fact that some of the responsibility here certainly lies on the parties and witnesses in an investigation, but the other part of that equation is you, the investigator, and we also have to accept responsibility for any delays. Sometimes we're working on these things as part of a team, and maybe there's another team member who is responsible for a component of the investigation. Maybe that's the scheduling of the interviews, or maybe that is a follow-up with a witness to find out if they received the particulars and have approved it. Maybe that's in the drafting of a report. Whatever the case might be, when you're working as a team, you want to make sure that you are communicating well, that you're able to keep track of what each team member is doing on a given investigation. And that requires some sort of a system. And for us, that is project management software. So there's certainly high-tech solutions out there, or there's a good old spreadsheet, right, where you simply list the investigations and the steps associated with that investigation, and you're populating and updating this document as you go along. So having a way to track, having a tool to track your investigations and making sure that it's broken out into the various stages and that things are happening according to the requisite internal timelines, that's extremely important, because as the investigator, you want to know, hey, is there something that we should be doing here to speed things up? Is there anything that we can do to speed things up? Again, at our firm, using these a project management tool helps us to know, are we getting things out the door in time? Is this investigation on track, or is it off course? What's the reason for that? And sometimes there's valid reasons, right? We had an investigation recently where we're waiting for the employer's IT department to produce certain information. They were, trying to grab access and forward to us some video evidence, and that took some time for them to coordinate. So you will get these natural delays in an investigation as employers maybe sort out the process for accessing video evidence, and then they actually go through the mechanism and the practical steps to access the videotape on the given day for the given time that you need, and then share that information. So there are natural delays and reasonable delays in the process, but you want to make sure that you're as an investigator, that you are on top of it. And the only way that you can be on top of it is if you have some sort of a tracking tool where you can then make sure that things are running on schedule. The final area where we experience delays in an investigation is with the reporting piece. And once you conduct an investigation, again, we just completed one that had a dozen complainants. So you can imagine with that volume of complainants, plus witnesses, plus meeting with the responding parties, and the amount of information that needs to be pulled together into a report, that's going to be a massive report. And you can't pull that together overnight. So that's an area where, again, if you're trying to fast track the investigation and move things along, you have to decide what sort of work product do I need at the end of the day. And in many cases, for routine investigations, you can get by with an executive summary or just a summary of the conclusions of the investigation. So what you want to do in order to arrive at that work product is just to make sure that as you're completing these interviews, that you are, after each interview, summarizing that evidence with respect to each of the allegations and dropping that into your draft report. And you're doing that as you go along for each party and for each witness. And when you do that as you go along, at the end of the interview stage, you already have 80% of a report or an executive summary completed, right? Because you've summarized this evidence. You're not there starting from scratch, having to look back over, this witness that I met with last week and what did she say, and refresh your memory and draft everything, from the ground up. Doing it as you go along is going to save you a lot of time. And all that requires essentially is the discipline to do it. So that's key, is that you have the discipline to set up a system and to follow that system, which is, once you complete the interviews, that you within a fixed amount of time are drafting the particulars, and for each individual, you are summarizing their evidence after that interview. We've found that to be a very helpful tool in terms of keeping our investigations on track. And so once you have that draft report, like I said, at the end of the interview process, you can turn that into, an executive summary, or you can look at that and you can quickly pull out, okay, here, based on the evidence that we received and that we reviewed, here's our findings for each of these allegations, and that can be pulled together into a short document for the parties to receive at the conclusion of the process. I don't want to leave you with the impression that an investigation report is not necessary. In many cases, you want to document, what occurred, from the investigation process itself and how it was conducted, to the evidence that you collected, and then certainly your conclusions on each of these allegations. And then many investigations, especially the ones that come across our desk, are complex, and there are a number of documents and maybe video evidence and text message evidence and those pieces that need to be referenced in a report, or might be critical pieces to how we arrived at our conclusions. So having all of that information in one place and organized in a systematic and a strategic way is going to be important for you as you maybe need to prepare that report to prepare for litigation, or defend against a legal action in the future. So what we would recommend is that you have all of this work product saved in a shared drive. And that way, whether it's you or another member of the team, someone can come in and pull the pieces together and draft that fulsome report at a future point in time, if that is necessary. If it isn't necessary, at least you have everything in one central location, so that if management needs to go back and review what happened on a file, they're able to. They have the benefit of all of that evidence and all the relevant documentation in one place. When it comes to conducting workplace investigations, keep in mind that we're doing this work, and when it comes to investigations, we're trying to do this on a standard of reasonableness, not perfection. Right? So we're here to do the best that we can with what we have. We're not here to conduct a perfect investigation. We're here to conduct a reasonable, sound, and effective investigation. So you want to focus on being fair to the parties. You want to focus on being thorough in the sense of trying to access all of the relevant witnesses and documentation and information that's out there to help you make an informed determination at the end of the day. When it comes to that determination, again, you're not trying to prove that something happened beyond a reasonable doubt. You're trying to you're making those conclusions based on a balance of probabilities. Is it more likely or not that this incident occurred as alleged? So again, just aim for being reasonable, aim for being thorough, but the goal here is not to be perfect. It's to do the best that you can with what you have. And we trust that the tools that we have outlined for you today give you a different perspective on the investigations and maybe help you understand some of the leverage that you have to move things forward and to bring your investigations to a fair and efficient conclusion. So with that, I'd like to open it up for questions.
The first question is, what about withdrawals on behalf of the complainant? So what are the compliance-related steps to take in this scenario?
So the complainant files a complaint, and then they say, you know what, I just want to take it back. I don't mean that. I don't want you to actually conduct an investigation. It really comes down to that obligation that employers have to look into these issues, right? Especially for provincially regulated employers. There's a difference here between what happens at the federal level and what happens at the for provincially regulated employers. At the federal level, there is a provision in the Canada Labor Code and the regulations that basically allow the employee to pull the plug on the investigation and say, you know what, I know I brought this forward, I don't want to participate anymore, and they can actually pull the plug on the investigation. That doesn't mean that there isn't still problematic behavior happening, nor does it mean that the employer is relieved of their obligations to address that issue, because ultimately, if they don't, the employer isn't relieved of legal liability, right? So think about this. At the federal level, the employee can pull the plug on the investigation, but that does not pull the plug on the employer's liability for that situation. So as the employer, you have to do something. And one of the things that you can do is to essentially, conduct a quasi-investigation. It's conduct a workplace assessment where you're going in and doing essentially all of the same things, and meeting with relevant witnesses, taking a pulse on what's happening in the workplace, finding out what the issues are, and doing the best that you can to address the concerns that you've uncovered. Now, this person who complained and then withdrew, they might even participate in that workplace assessment. Certainly, you can invite them to participate. They may or they may not. What you don't want to do is to say, okay, well, they withdrew, I'm not going to do anything. Because again, even at the federal level, where the individual has that right, it doesn't relieve you, the employer, of liability. So you still want to do something to address the problematic behavior that's been brought to your attention. At the provincial level, your obligation is to look into incidents of problematic behavior, right? So not complaints of problematic behavior, incidents of problematic behavior. So that means when you're aware that there's something troubling happening and that there could be a policy violation or whatever the case might be, even if the person doesn't want to participate, you still have to look into it and conduct an investigation. So at the provincial level, or for provincially regulated employers, the employee can't pull the plug on the investigation. You acknowledge their wishes, but you have to move ahead. And again, for employers, the worst place for you to be, right, is to say, hey, this person came forward. They complained about sexual harassment, but she told me don't do anything about it. So we didn't do anything about it because she didn't want us to go ahead. And then a few months down the road, or whenever it is, you get a claim from the Human Rights Tribunal, right? There's a human rights claim or a constructive dismissal claim that's brought against you, and the other side's asking for all this extraordinary damages. And what do you think that human rights application or that lawsuit is going to say? It's going to say, I brought these issues to your attention. You didn't do anything about it. You created or allowed this poisoned work environment to continue. So now I'm suing you for all of these damages and extraordinary damages. You don't want your defense to be, well, you told us not to look into it, so we didn't. Like, that's not going to help you when you're sitting in front of a judge. So even if someone doesn't want to participate, you, the employer, have to, weigh, the risk. And are you dealing with a serious complaint? Are you dealing with, something on the low end of the continuum of bad behavior? And then you got to make a judgment call. But more often than not, once something is brought to your attention, you're going to want to look into it.
The next question is, do you cap your hours with your clients at the beginning?
We work with our clients to find out what they need from us. So in most cases, clients come in and they have a serious allegation, right? They've got a dozen employees who've come forward and said, "Hey, I've been experiencing discrimination. You're not doing anything about it." And so the issue isn't so much on the capping of the hours. It's just, what does the client need from us? Do they need us to come in and investigate and to meet with these folks and solve the problem? Do they want us to be in the background and advise them in terms of, hey, have we done the right things to this point, or what should we do going forward? We work with the clients to figure out what they need from us, and then with respect to hours, then we would let the client know, here's what you're looking at in terms of budget or the number of hours that are likely required, and the client makes a decision as far as how they want to use us and what expertise they need from us going forward.
Okay. Next question is, do you use paragraphs or points when summarizing the discussions? Sometimes parties repeat and circle back on subjects, and the flow seems important versus combining like points and paragraphs on like subjects.
When I interview a witness, we record everything verbatim. And that's just the way that I was taught, and I'm able to, to type and to keep up. When we meet with folks, sometimes we'll have an audio recording of the interview, and we'll create a transcript of the interview and allow the witness to confirm that, hey, this transcript is accurate. These are the questions you asked. This is how I responded, and this accurately captures my position on these issues. So we would prepare detailed notes, and then from there, if we need to circle back, we will fill in the blanks. If not, we move ahead and make our conclusions based on what we've collected.
We had a question on LinkedIn about whether or not you have dealt with unions and unionized organizations and how that relates to this particular topic.
I have extensive background working with unions. So at the beginning of my career, I was actually I started out working at the Ministry of Labor, and then after I was called to the bar, I worked at a management side labor and employment firm. So that work involved a lot of negotiating with unions, whether that's collective agreements or pay equity agreements, and resolving grievances. Then when my practice evolved to conducting investigations, and this would have occurred between 2006 and 2010, we've worked extensively with unions to resolve workplace issues. So I've conducted many investigations in unionized environments. I've also conducted many investigations for unions themselves, right? Because keep in mind, unions are employers too. And so there have been many occasions where a union has had issues with some of their own employees, and they have worked with us to investigate and unpack those issues. So we have extensive experience working in unionized environments, and happy to provide any advice or guidance that we can if you have a need there.
Okay. Next question is, would it be premature to give an estimate of hours with clients at the beginning, because we really don't know until we get into an investigation what it will cost? So, and our all people in your organization involved present in your intake meeting with the client?
So in terms of the first question, as far as is it premature to give an estimate of the hours? I don't think so. I think experienced investigators are able to collect the details that are necessary and indicate based on their experience, here's what it's going to cost. And and I put that on the shoulders of the investigator. So certainly, I feel very comfortable, peeling back the layers and asking the client the right questions to make sure that we, understand not just the nature of the complaint, but the individuals who are party to the complaint and other nuances in there in terms of other litigation that might be contemplated or that might have been initiated. Yeah, you want to approach it from a few different perspectives. You want to collect all of those data points, and then you're able to give an accurate assessment. And you can do that with the proviso in there that, look, if there are more allegations, or if the mandate changes, then that's obviously going to change the quote, right, and the hours that we anticipate. But again, I think going back to if you're an experienced investigator, you should be able to give a reasonable budget to the client. In terms of the intake meeting, we typically would just have one lawyer involved at that intake, and that individual would be required to record the relevant information and with the client to just identify what their needs are and what their expectations are, and then it just comes down to taking that and putting that into our workflow and communicating with the team members that are going to be working on that mandate. So to answer the question, yeah, at the outset, we don't have a system where every single team member is present at the intake meeting.
Okay. That is all the questions that we've got for the moment. Are there any last minute questions before Dorian moves on to the end? Okay, I don't see any, Dorian.
Okay. Well, thank you all for those questions. I want to make everyone aware of the workshops that we have coming up, and so we have a couple dates in April on the 23rd and 24th of April. It's our 2-day intensive workplace investigation workshop. We are going to take you through an investigation from beginning to end. We want to make sure that you've got the confidence to, when this complaint comes across your desk, that you can pick it up and run with it and know that you're doing a good job, that at the end of the day, your investigation is going to stand up to scrutiny. And we do that with live actors, where you get to examine a complainant and a respondent in real time. You're going to learn how to pull together that evidence and reconcile that with what the witnesses have said in order to make difficult credibility assessments and then ultimately reach a conclusion on these allegations that have been made. And then once you've done that part, then the final part is pulling it all together into a report. So we're going to take you through the sections of an investigation report and make sure that you have all of those elements and that you're able to draft a report, again, that accurately reflects what occurred and your process and captures the information that you need to capture to meet your statutory obligations. So I encourage you to keep that in mind, to contact us. You can use this QR code, or you have my contact information on the screen. Please reach out and let us know if you're interested in that workshop. We'd be happy to register you and your team. Spaces are limited, so please do get in touch with us soon so that you have your space reserved before it's taken. And if you have ideas for future webinars, please let us know. We want to make sure that we're putting content out there that you're going to enjoy. So if you enjoyed this presentation, please let us know about that. And if there are other topics that you want us to speak about, let us know, and we'd be happy to consider those for future events. Thank you, everyone, for your participation today. It was a pleasure being here with you, and wish you all the best going forward. Thank you.